Did Jamie Raskin just catch Pam Bondi in a massive cover-up regarding the missing Epstein files? Greetings to the Patel Report, revealing the truth behind classified information. 52 pages. That is the figure. 52 pages of FBI interview records in the Department of Justice database on a Tuesday. Gone by Thursday. Not reclassified. Not restricted. Not transferred to a secure review facility. Gone. Removed from the public record entirely. And every one of those 52 pages had something in common. Every one of them featured the name Donald Trump, but that was just the beginning. What the missing 3 interviews featured is why the Department of Justice is battling to keep them sealed. The FBI interview report is called an FD 302. That is the official classification. An FD 302 is the official FBI witness interview record. Every word uttered in that interview goes into the FD 302. Every detail, every document referenced. The FD 302 is legally significant. It becomes part of the evidentiary record. Government suppression of an FD 302 is not administrative. It becomes material evidence in its own right. It becomes the kind of material that prosecutors form obstruction cases around. Now pay close attention to what happens next. This is the document that altered the entire scope of the Epstein investigation. The woman had been interviewed by FBI agents on 4 distinct occasions. The first interview was in 2019. That interview covered her account of Epstein's operation in general terms. That interview was unveiled with the public document batch. The second interview was executed 6 weeks later. That interview asked specific follow-up questions about locations and individuals she had named in the first session. That interview was not unveiled. The third interview was executed 3 months after the second. A different set of agents. That interview has not been unveiled. The fourth interview was executed 11 months after the third. A senior FBI official was attending. That interview has also not been unveiled. Subscribe to Patel Report files right now. When those reports are forced public, Patel Report files will break down what they contain. This is what the cameras did not record when Raskin joined the committee room that morning. He carried a printed document that was not on the official evidence list. The document was a comparison. 2 columns. The left column displayed the DOJ's public statement about Epstein-related FBI interviews unveiled. The right column displayed the internal evidence log from the Maxwell trial discovery materials. The numbers did not match. 15 documents were listed in the Maxwell discovery log for this specific witness. 7 of those 15 documents appeared in the public database. 8 did not. 8 witness records listed, verified, gone. Who decided which 8 would vanish? That is the question. And the 3 missing FD 302 reports answer. In exactly 47 seconds, Raskin will drop that comparison document on the witness table. Watch what Bondi's attorney does with his pen when the 2 columns become visible on camera. Pam Bondi had swore under oath before the committee on February 11th. She had stated that there was no evidence Donald Trump had committed an offense. She stated it directly. She stated it without qualification. She stated it as a matter of official DOJ position. What she did not state was this. Before her testimony, the DOJ had removed FBI interview records from the public database. Those records came from a specific witness. That witness had provided a specific account. That account named Donald Trump at a specific location. That location was Mar-a-Lago. That account was documented in 3 separate FD 302 reports. All 3 had been removed before Bondi sat down to testify. For years they had said the Epstein files were being unveiled without meddling. Today, in this room, the evidence of that meddling was sitting in 2 printed columns on a table. The Maxwell trial discovery materials are a separate legal record. They are a court record. They were assembled under judicial supervision as part of a federal criminal case that resulted in a conviction. They cannot be retroactively altered. They cannot be reclassified. They are enduring. And that enduring record displayed 15 documents for this witness, 15 verified FBI records, 7 in the public database, 8 missing. One of those 8 was an FD 302 session executed by a senior FBI official. The date of that session was 11 months after the initial interview, 11 months after the first account was given. An interview executed with a senior official attending is not standard. It is executed when the account has been deemed important enough to require senior review. That interview was executed. It is in the court record. It is not in the public database. Drop a comment below right now. 4 FBI interviews executed with the same Epstein witness. 1 unveiled, 3 removed, before Bondi swore under oath that no evidence existed. Do you believe that was a fluke? Write your answer. I read every single one. The second document was bleaker. Raskin yielded it 43 minutes into his questioning. The document was a DOJ internal review notation. The notation was dated January 14th of this year. The notation ordered the Department's Classification Review Board to conduct an expedited assessment. The scope was all Epstein-related witness interviews referencing current or former senior government officials. The notation listed a timeline. Completion was required before the public document release scheduled for January 28th. The public release happened on January 28th. The FD 302 reports were not in it. The expedited assessment had found them and removed them before the release, before Bondi's testimony, before anyone in that hearing room had been told they existed. The log files do not fib. January 14th. Expedited classification review. January 28th. Public release. February 11th. Bondi testifies under oath. The 3 FD 302 reports are not in the public record at any of those dates. They were not missed. They were removed on a timeline. Now I need to stop for a second and say this. If the American people need to know what those 3 missing interviews contain, hype this video right now. The hype button is right next to like. You can hype 3 times a day for free. We have 7 days to get this into the top 100 most hyped videos on YouTube. Every single hype counts. Do it now, then keep watching. The legal word for what Raskin found in those 2 columns has a specific meaning, and that meaning does not use the word fluke. The legal word is perjury. Perjury is a federal offense. It requires proof that a sworn statement was purposely false on a material matter. The statement Bondi made under oath was that no evidence existed. The FD 302 reports she had removed from the public database before testifying were evidence. They were official FBI records. They were part of a federal criminal case. They were in a court record that cannot be altered. And they featured a specific account from a specific witness about a specific location, Mar-a-Lago. If those 3 reports had been public when Bondi testified, she could not have made that statement. She made the statement because the documents had been removed before she sat down. That removal was documented. The documentation was in Raskin's second column. The next question did not come from a Democrat. It came from a Republican who had co-sponsored the Epstein transparency legislation. Thomas Massey had been watching from the Republican side of the dais for 43 minutes. He is not a lawyer. He is an architect. He reads documents the way architects read specifications, searching for what is stated, searching for what is not stated, searching for where the numbers stop matching. He leaned forward and asked Bondi one question. He asked her when she had been informed of the January 14th classification review notation, not whether she had approved it, not whether she had ordered it, when she had been informed. The question presumed knowledge. Bondi's response confirmed the assumption. She said that classification review decisions were made through the suitable internal channels. She did not say she had not been informed. She said the channels were suitable. Raskin set down his pen. He looked at the two columns. He described what those suitable channels had yielded. A timeline. 3 FBI witness interviews naming a current senior official removed from the public record before the Attorney General swore under oath that no such evidence existed. He asked whether Bondi found that timeline suitable. Bondi reached for her binder. Raskin said he had not finished his question. The binder stayed closed. If you are still watching, what comes next is why this video exists. The congressional record now contains Raskin's 2-column document. The Maxwell trial record still shows 15 witness files. The public database still shows 7, and 8 FBI records are still missing now. What the cameras did not record was this. After Raskin's second round, a senior committee staffer carried a printed request to the Majority Counsel's table. It was a formal request for the DOJ Classification Review Board's full January 14th work product, not a summary, the full internal assessment, every page, every decision, every signature. The Majority Counsel accepted the printed request without comment. The request was added to the committee's formal record. The 4-day response window began that afternoon. The 4-day window has elapsed. No full work product has been provided. Ted Lieu watched the exchange from his seat at the end of the dais. He is a former military prosecutor. He had seen classification review processes used before. He had seen them used correctly. He had seen them used as barriers. He noted that the January 14th notation did not use the phrase public interest review. It used the phrase expedited assessment. Those two phrases have different legal consequences in the context of congressional disclosure requirements. An expedited assessment executed on a compressed timeline before a scheduled public release has a specific legal status. That status is different from a standard classification review. Lieu sent a written question to the committee record after Raskin's time expired. Liu's written question asked for the legal authority. Specifically, the authority allowing an expedited assessment to authorize pre-release removal of court-verified evidence. No written response has been provided. Those 8 missing FBI records belong to the American people. Hit that thumbs up for Patel Report files if you believe that statement is fact. Bondi left the hearing at 4:17 the afternoon. She had been in the room for 4.5 hours. She had referenced her binder 43 times. She had debated Texas crime statistics. She had debated the Dow Jones. She had not debated the 3 missing FD 302 reports. She had not debated the January 14th notation. She had not debated the expedited assessment timeline. She had not been asked whether the assessment had been executed with her knowledge. She had been asked only when she had been informed, and her answer had confirmed that she had been informed. Watch her hands. That micro-expression crossing Bondi's face in the 47 seconds between Massey's question and her response. The jaw holding. The hands flat on the table. The particular stillness of someone who has calculated the exact minimum answer required. Not the true answer. The minimum answer. There is a difference between those two things. Raskin's 2 columns documented that difference with 14 verified entries. We have a WhatsApp channel. If you want to know the instant those 8 missing records go public, come find us there. Go to our YouTube profile and tap the WhatsApp button. Takes 5 seconds. The Maxwell trial court record is not going away. 15 documents verified, enduring. The public database has 7. That gap is 8 records. 8 records in the court log. logged as FBI interviews executed over 33 months, not in the public database that Bondi's DOJ released and called complete. Complete was the word the DOJ used. Complete. Raskin's 2 columns turned that word into a question with 8 specific answers still missing. The expedited assessment notation carried a signature. That signature belongs to a senior DOJ official. That official's name is in the notation. That notation is in the committee record. The notation is not classified. The signature is not redacted. What the signature authorized is documented. What it removed from the public record is documented in the Maxwell trial log. And the gap between what was authorized and what the public received is documented in Raskin's 2 columns. That gap has a name in federal law. That name is in a 4-page letter Ted Lieu sent it to the Deputy Attorney General 9 days after this hearing. The letter used the word perjury. The response to that letter has not been provided. Share this for Patel report files. Share it with someone who still believes those 3 missing reports do not exist. They exist. They are in a court record that cannot be altered. They were removed from the public database before Bondi swore under oath. The timeline is documented. The notation is signed. The gap is measurable. 52 pages, 8 records, 4 interviews, 1 unveiled. That number is not a fluke. When those 3 reports go public, every word Bondi said under oath becomes a different kind of document, the kind with consequences.